You're watching 10 Tampa Bay. Courtney Robinson alongside Frank Wiley. Within the last couple hours, Florida and Texas took on social media in arguments before the nation's highest court.
All right, so here's the issue: how the First Amendment applies to social media sites. Jared Hill explains the court's decision could impact you and how millions of Americans interact online.
It's the First Amendment question for the internet age. Can the government force social media companies to carry content they've deemed objectionable?
The platforms do not have a First Amendment right to apply their censorship policies in an inconsistent manner and to censor and deplatform certain users.
Monday, the Supreme Court heard arguments in two cases from Florida and Texas, saying states should have a say in the matter.
It would require these social media platforms that are creating the compilation of third-party speech to fundamentally alter their product that they're offering. We think that's an infringement of speech, and the court should say so.
The Republican-led states passed their laws after Facebook and X, Twitter at the time, banned former President Donald Trump following the January 6th attack on the Capitol, concerned his posts would incite more violence. Social media sites argue they're more like newspapers and should be able to make editorial judgments. But the states say these platforms are more like telephone companies and can't kick people off. Several justices commented on how broad the laws are, and in the case of Florida's, its lack of specificity.
We're not quite sure who it covers. We're not clear exactly how these platforms work.
I might have heard the justices trying to find a way to kick this back to Florida, back to Texas, and have a more developed record before they make a big First Amendment ruling.
A decision is expected by June. Jared Hill, CBS News, New York.